Greetings, everyone, and welcome. I'm getting our special guest ready, so if you could just be patient for just a moment, and we're going to get our guest on. In the meantime, I'm going to throw in another song for you guys real quick, because I guess we got to get some little thing here. I get about 2 or 3 minutes just to get our guest ready backstage here, and then we're going to get rolling with the civil procedure for Illinois Code of Civil Procedure. We're going to be focusing on the foreclosures and the repossession sections here, which ties into our adverse possession that we were previously going over in American jurisprudence. So bear with me for just a moment, and we're going to get the guest ready backstage and have him on here in just a moment. So about 3 minutes. I'm going to put another song on for your listening pleasure in just a moment. All right, guys, thanks for waiting. I'm just getting our guests ready backstage here. And we're going to be going over the civil procedure for the Illinois compiled statutes. Specifically, we're going to be going over the section here that has to deal with property, possession, foreclosures, and adverse possession. So we're going to look at some statutes of limitation here and things that kind of pigeonhole into with the live stream we did on American jurisprudence. And we're going to get this thing here going here. Pardon me for a second. Interact. Okay. So I think we're here at judgment here. Let's see. We can get back a little bit here. I'm still waiting for Audit them to hop on. Let me check backstage and see if he's there yet. All right. In the meantime, I'm trying to get right to the page we want to start on here. All right. So it's there we go. We're almost there. Thought this was it here. All right. Okay, so let's see here. All right, so judgments. This is default judgments and confession. The court shall grant any party any affirmative relief to which the party may be entitled on the pleadings and proofs. Judgments shall be made in the form required by the nature of the case and by the recovery or relief awarded. More than one judgment may be rendered in the same cause. If relief is granted against a party who, upon satisfying the same in whole or in part, will be entitled to operation of law, will be reimbursed by another party to the action. All right, I may get here. The determination in favor of the plaintiff on an issue as to the truth or validity of any defense in abatement shall be at the defendant answer or otherwise plead. So, any defense in abatement shall be that the defendant answer or otherwise plead. So, any defense in abatement shall be that the defendant answer or otherwise plead. So we need to have a plea, in other words, for a validity. Except so otherwise limited by the subsection, any person for a debt bona fide due may confess judgment by himself or herself or attorney, duly authorized without process. Give me one moment here. I'm going to try and pull up audit them. No sound. Shit. All right, check. Do we have sound on my end? Let me check on the YouTube end, guys. Sorry about this. Got started a little bit late here, and just wondering why. It seems like we got sound.
All right, check.
Okay, so now we gotta get audit them back with sound. I'm gonna try this one more time. Give me one moment, guys. And let me get audit them on the panel here. I'll throw on some music again while we're waiting. Try a different song this time, huh?
pursuant to the fundamental.
Okay, guys, I think we have our guests here. Audit them. Are you in the house?
Hello there. Can you hear me?
Nice. I think we got audio out there. Is anyone else out there can confirm we have good audio?
Can you hear me now?
I hear you fine. I just want to make sure everyone else can hear you out there well. I'm going to check on myself here real quick. Nice. I think we got audio out there. Is anyone else out there can confirm we have good audio?
Can you hear me now?
Oh, yeah, you're coming in nice and clear on them, so we're good to go. All right. So do you want to give a quick introduction here for the audience? Hello?
Yeah.
Yeah, okay, go ahead. Give a little introduction. I'm going to get the live chat ready on the screen, too. While you're talking.
Beautiful.
Yeah.
We're going to be going over Civil Procedure 735 ILCS Section 5. Code of Civil Procedure. Make sure you have either two things, Esquire pencil or photogenic audio memory.
Hang on a second. I got to type in a few things. Yeah, see if that worked. Yes. All right. So we're live. We're good to go. Okay, so let's get down here. What we're looking at here is, look at this. All right, so no power to confess judgment shall be required or given after September 24th, 1979 in any instrument used in a consumer transaction. Any power to confess given in violation hereof is null and void. Any judgment entered by a court based on such power shall be unenforceable. So consumer transaction as used in this section means a sale, lease, assignment, loan, or other disposition of an item of goods, a consumer service, or an intangible to an individual for purposes that are primarily personal, family, or household. Judgment by default may be entered for want of an appearance or for failure to plead, but the court may, in either case, require proof of the allegations of the pleadings upon which relief is sought. So keep that's an important one there. Whenever there's a default judgment.
Can you hear me?
Yes, I can.
I'm putting up the chat right now. The
excellent
video.
All right. So let's see. Let me see. Can you see what's going on here? Oh, let me turn on the camera. I'm sorry. Shit. There we go. Now you should be able to see what we got going on the screen. Audit them. Do you see it?
Yep. Now it's on. Perfect.
Yeah. Okay. All right. Now we're all on. So the court may, in its discretion, before final order or judgment, set aside any default, and may, on motion filed within 30 days after entry thereof, set aside any final order or judgment upon any terms and conditions that shall be reasonable. You get that? So this is another important section, E. So do you see which section we're on here, guys? We got to see at
perfect
735 ILCS from Chapter 110, Paragraph 2, 1301. So this is Section 2-1301, Default Judgments and Confession. So again, this is what happens when someone doesn't show up to court. And like you're looking at those vacant properties and such, that might be a disposition of them. But typically these things just end up in the hands of large, banks.
Yeah.
By the end of December. Hang on one second. Let me just speak here to Deborah. I have, I want to do the federal complaints. I had to postpone that one because it was you and You Have Rights, Cops Have Duties. Are both in the process of drafting, and he couldn't make it tonight. So instead, I just, since I had this live stream set up, I decided to work on this one here with Audit Them, since he's more familiar with the Illinois procedure. But what I want people to see is how you read through these in any state and be able to understand how these kinds of judgments can be entered in without even an appearance in court. And this happens every single day. And in a lot of ways, it's done under, it's almost barely lawful.
It's done under the resto.
Well, it's done under acquiescence, and it's really the fault of the people that don't that don't pay attention, keep their eyes out like we get there. Chevy in the house, nice, cool. All right, so I think we get a
Chevy duty.
Yeah. So Deborah Rogers is still in here, so I wanted to get that part over to her. So we're postponing the one on the complaints, drafting complaints, when we get you have rights, cops have duties in here as well. All right. So let's proceed here.
Hey, go back up. What number is this? 735 what?
Yeah, we're still 735 5/ and this is section 2-1301.
Perfect.
Okay, so it's from chapter 10, paragraph 2-1301. Hey, LA Spike in the house with the number 7 Esquire pencil, it looks like there. Excellent.
Number 2 pencil.
All right, so let's get back to where we were here. So do you see ways this is happening? So far we have A. Well, the judgment's granted A. The court shall determine the rights of the parties and grant to any party any affirmative relief to which the party may be entitled. So that's when the plaintiff is making an affirmative relief, right, on the pleadings and proofs. See this? Entitled on the pleadings and proofs. Judgments shall be in the form required by the nature of the case and by the recovery or relief awarded. More than one judgment may be rendered in the same cause. So you see what's going on here? There's a lot of things going on. And that's all on A, right? So this is really the general thing from the final judgment. So an important thing, again, to look at it here is, and upon showing that satisfaction has been made, render a final judgment against the other party accordingly. Okay? So satisfaction. How do you satisfy the law here? So let's look here. A determination in favor of the plaintiff on an issue as to the truth or validity of any defense in abatement shall be that the defendant answer or otherwise plead. You get that? So in any abatement.
No, that's heavy duty.
What's an abatement? Let's look this up in Blacks here. Give me 1 second here. Okay, all right, you're still there. You still there on them? Are you still
Mic
there?
check. Hello.
Yes, all right. Just making sure. All right, keep you here for Blacks. All right, I got to interact in here. We're using 9th edition of Black's Law. Let me get it over there. Yeah, so we're using 9th edition, and we're going to look up abatement. So we're just going to scroll through here. I think we can find abatement pretty quick. Oh, wow. That moved too quick. All right, I'm not going to do that again. In the meantime, while that's catching up there, I'm going to go ahead and search it in another way and find it quicker. Let's see here. Come on. Abatement 25. Oh, wait, that's just submit here. I see 37. Nope. 31. There we go. Okay, here we go. Abandonment of contents. Abatable abatement. The act is 14th century now. The act of eliminating or nullifying abatement of a nuisance. Okay, suspension or defeat of a pending action for a reason unrelated to the merits of the claim. You see how abatement, well, we know abate just means, to eliminate or nullify in common language. We look at definition 2, the suspension or defeat of a pending action for a reason unrelated to the merits of the claim. The defendant sought abatement of the suit because of misnomer. It's put it the wrong name. See plea and abatement under plea. So let's look at this here, because we have these little paragraphs here. Although the term abatement is sometimes used loosely as a substitute for stay of proceedings, the two may be distinguished on several grounds. For example, when grounds for abatement of an action exist, the abatement of the action is a matter of right, but a stay is granted in the court's discretion. And in proper circumstances, a court may stay a proceeding pending the outcome of another proceeding, although a strict plea in abatement could not be sustained. So there it is. The abatement is a little bit heavier than a stay. So abatement is something where it's nullifying, right? It's defeating, suspending an action. The act of lessening or moderating, diminution in amount or degree, abatement of the debt. Now look at that difference in definition. From eliminating or nullifying to diminution in amount or degree. Abatement of the debt. Wills and estates, the reduction of a legacy, general or specific, as a result of the estates being insufficient to pay all debts and legacies. The abatement of legacies resulted from the estate's insolvency. Okay. Archaic, the act of tortuously entering real estate after the owner dies and before the legal heir enters. Wow. So interesting.
Legal heir.
Yeah, interesting stuff here. Abatement clause, a lease provision that releases a tenant from the rent obligation when an act of God or other specified reason precludes occupancy. Abatement clause, interesting, 1890. So the abater is a person who eliminates a nuisance. Interesting stuff we find here. All right, well, let's get back to the lesson here. So in this circumstance here, I think it's number 2, the suspension or defeat of a pending action for a reason unrelated to the merits of a claim. So let's go back to the AMJUR. I'm sorry, the rules of civil procedure. Oh, shoot. Wrong one there. Okay, there we go. So determination in favor of the plaintiff on an issue as to the truth or validity of any defense in abatement. The defense in abatement shall be that the defendant answer or otherwise plea. The determination in favor of the plaintiff on an issue as to the truth or validity of any defense in abatement. What's a defense in abatement? The defendant answer or otherwise plea. Determination in favor. All right. It seems to me that the defense in abatement, gosh, see how they use the wordings here. The defendant sought abatement of the suit. See, now I'm looking at it from here, plea and abatement under plea. So we could check that out too. You're still there? Okay, it's muted. Let's look
On.
up. Yep, you're on. Just double checking. So we gotta see plea abatement.
I'm on like Tom.
Yeah, let's see plea.
Hold on, bro. I'll be right back. Let me
Sure.
get a bottle of water.
You got it. All right, so we're looking at.
You want me to send you one virtually?
Yeah, sure. Let's see, plea of abate. Plea and abate. Wow, it's going to be way down here. Plea has to be King's Court. Here we go. Oh, Court of High Commission. Jeez. Pleas all over the place in here. Now I have a terrible terrible document to search with this because it's a scanned document, so I'm not getting every occurrence of it in here. Let's see, am I on the P yet? No, geez. All right, we're getting close here. Oh my gosh. Well, plea is a very common word in Black's Law Dictionary. Oh, wait, nolo plea. Oh my gosh. I think there's a plea for every letter of the alphabet here. Wow.
A, B, C, D, E, F, G.
All right,
Nah, bro,
finally, here we go. Oh my gosh. Oh my gosh, a lot of them. So this is going to be fun. $12.95. Let's just cut to the chase here. Oh my gosh. Interact. $12.95 is the page we'll start with here. Loosh. Lots of pleas here. Here. Here we go. Here we go. Insanity plea. All right. Plea. Oh my gosh. So, in case anyone was wondering what the word meant, it is from the 13th century. An accused person's formal response of guilty, not guilty, or no contest to a criminal charge, also termed criminal plea. So that's interesting, from the 13th century, and it's about a criminal charge, not even a civil, it says here. You got blind pleas, conditional plea, guilty plea, 1942, geez. Insanity plea, negotiated plea, nolo plea, not contest or admit guilt. Not guilty plea, provident plea. So there's lots of stuff here for pleas. And common law, the defendant's response. Okay. Here we go. At common law, the defendant's responsive pleading in a civil action, declaration. And I've already forgotten the actual word we were looking for. It was plea abatement. 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 Oh, wait, I gotta get back to this one. Shit. There we go. Okay. Suspension, double plea, plea of privilege. Plead. To make a specific plea. Writ, jurisdiction, declaration, pleading, accusatory pleading. Here we go. Amended pleading. Plea bargain, special plea, rolled up plea, pure plea. Lots of pleas. So looking for the abatement. Special pleadings, pleading the fifth. If anyone sees it, please let me know. Alternative pleading, artful pleading, code pleading, plead over. Lots of pleads. Here's plead the fifth again. Take the fifth. Yeah, I can't find. I wonder if it said to look for it here, though, didn't it? Plea of pregnancy, plea of privilege, plea of release, sanctuary, tender, pleasure, appointment. Okay, so there's one other thing I could probably do here. Plevin is a pledge. That's interesting. Okay, so here we go. We're gonna look up. We're gonna find that abatement defense here, because we need to be clear on this language here, because you can't have someone else correct you on it, after the fact. You have to be very clear on what they're saying here, so there's no question. So it was a plea and abatement or something, wasn't it? All right, let's look at this, page 31 again. And we're looking at Come on. There we go. We're seeing abatement defense, right? Where did it say that here somewhere? Never seen it here. Abatement clause. This is why I like having paper books too, because you could stick little bookmarks and stuff in there. So we see defendant sought abatement because of a misc plea in abatement. Plea in abatement. Damn it. So that's what it was. Plea in abatement. Let me try that. Damn. Oh, I gotta search it a different way. Holy shit. Ah, much better. Okay, cool. Plea to the declaration. Plea and abatement. Non-issuable plea. Man, it's hard to find this. Plaintiff on the record admission defense cannot be avoided. Under plea. Well, darn it. You're just there. Yeah, OBS is better than any of that stuff. All right, so let's just move along with this because I don't want to drag this on too far. Okay, so here we go. Interact. All right. Except as otherwise limited by this subsection C. Any person for a debt bona fide. Debt bona fide. So they need to have something where it's actually proven to be a debt. May confess judgment by himself or herself or attorney duly authorized without process. May confess judgment. So, the application to confess judgment shall be made in the county in which the note or obligation was executed, or in the county in which one or more of the defendants reside, or in any county in which is located any property, real or personal, owned by any one or more of the defendants. A judgment entered by any court in any county other than those here specified has no force and validity. So what we're looking at here is may confess judgment by himself or herself or attorney duly authorized without process. May confess judgment. So how do you confess judgment, huh? Let's see what else we got going on here. Let's see. Yeah, OBS is open broadcasting software, so it's something where you're not going to have to pay to use, and you don't have an intermeddler like a third party there that's intercepting all of your transmissions. As it stands, if you're streaming to YouTube, it's really between you and YouTube. So when you put it, an interloper in there like StreamYard or Streamlabs or any of the other ones, there's some competing products out there that are newer and better. Those are pretty old, and there are other ones that give you much better value too if you're going to get the paid version. However, it seems like a lot of people do take it out of convenience. Now, the difference is when you use OBS, it's going to work better and faster, but it's going to have a bit of a learning curve because you're going to have to learn the software. But then again, it's all being done right from your machine, so there's no, again, interloper. Now, if you want to bring a guest in like I'm doing with Audit Them, then you need to figure out a way to bring them in. I myself, I host it myself, so I don't have the intermeddlers. But that takes a little bit of skill to do. And I'm not even sure. Is Audit Them still there?
Hello there.
All right. So he's still here. So it's working good as that goes. That being said, let's continue here and see what else we can dig up. But I just want to let everyone know that, No, it doesn't require 2 monitors, but I do use 2 computers and a phone when I'm doing this stuff here, just because I'm trying to monitor it all and I don't have anyone helping me. So I pretty much do it all myself here, and I'm definitely running it hard. I mean, all my stuff is like overtaxed. That being said, OBS is very what should I say, compliant with old computers. So if you have an older computer, then you're better off with OBS than any of the other softwares, because it's going to work well with the old computers. You can configure it to work with your limitations there. But it's good stuff. I like OBS a lot. The more I learn about it, the better it is. And you can do so much cool stuff with it. And it's just unlimited. It's just how much time and effort you want to spend enhancing it. All right, let's continue here. So the application to confess judgment shall be made in the county. All right, we get all that stuff. No power to confess judgment shall be required or given in any instrument used in a consumer transaction. Okay. Shall be required. No power to confess shall be required. Deborah Rogers asked about laptop. Yeah, you can use a laptop. I mean, again, the better the machine you have, the better you'll get as far as results. But don't, if you want to do some really cutting edge, when you see the cool stuff looking like the news, TV news, yeah, that's going to be, you'll need a high-end computer for that. Gaming computers, I think, are supposedly the best for that. Make sure it's something with a graphics card. It will help. Nonetheless, let's continue here. Get going here. So in 1979, some things changed, right? So sale lease, we already went over this part. So the judgment by default might be entered for want of an appearance or for failure to plead. So if there's a judgment default, that means someone didn't show up. So yeah, please hit the like, guys, if you could. If failure to plead, but the court may in either case require proof of the allegations of the pleadings upon which relief is sought. Interesting stuff here. The court may, in its discretion, before final order or judgment, set aside any default, and may, on motion filed within 30 days after entry thereof, set aside any final order or judgment upon any terms and conditions that shall be reasonable. So set aside any default, and may, on any motion filed within 30 days after entry thereof, set aside any final order or judgment upon any terms and conditions that shall be reasonable. So at the court's discretion and before final order or judgment, set aside any default. Okay, so that's filed within 30 days after entry thereof. So you got to check 30 days after an entry of the default judgment, right? And then that should be, you could still have it set aside for a reasonable, right? Upon any terms and conditions that shall be reasonable. So it's up to the court at its discretion. The fact that any order or judgment is joint does not deprive the court of power to set it aside as to fewer than all parties, and if so, set it aside remains in full force and effect as to the other parties. So that's if you have, I guess that would be something like a what would you call it, geez. The deeds, oh Lord, all right. If any final judgment is entered against any defendant who has been served by publication with notice of the commencement of the action, and who has not been served with a copy of the complaint or received the notice required to be sent him or her by mail or otherwise brought into court, and such defendant or his or her heirs, legatees, or personal representatives, as the case may require, shall, within 90 days after notice in writing given him or her of the judgment, or within 1 year after the judgment, if no notice has been given, appear in open court and petition to be heard touching the matter of the judgment. The court shall, upon notice being given to the parties to such action who appeared therein, and the purchaser at a sale made pursuant to the judgment, or their attorneys, set the petition for hearing, and may allow the parties and the purchaser to answer the petition. If upon the hearing it appears that the judgment ought not to have been made against the defendant, it may be set aside, altered, or amended, as appears just. Otherwise, the petition shall be dismissed at the petitioner's cost. If, however, a sale has been had under and pursuant to the final judgment, the court, in altering or amending the judgment, may, upon terms just and equitable to the defendant, permit the sale to stand. If upon the hearing of the petition it appears that the defendant was entitled under law to redeem from the sale, the court shall permit redemption to be made at the time within 90 days thereafter, upon terms that are equitable and just. So, to redeem from the sale, right? So, I guess it's shall permit redemption. So, what does it actually mean when we say redemption in the legal term? And that's what we're going to have to find out right now. So, we're going to find out the legal Black's Law definition of redemption. All right, redemption. All right. Wow. Well, jeez. All right, it's going to be way down here then. Now, sale with right of redemption. Let's look at this real quick here, 1484. So this word here, it kind of caught my eye. The right page. Here we go. Oh, here we go. Sale with the right of redemption. A sale in which the seller reserves the right to retake the goods by refunding the purchase price. Okay. I think we see what's going on here. Let's see, a purchase agreement as opposed to specified. See, the sales price will not be modified. Okay, just checking this out here. Yeah, so sales with right of redemption. So that's kind of what we're talking about here in a way. All right, let's get back to what we were looking for, though, which was just redemption. Right of redemption. See redemption. Everything see redemption, so let's see redemption. Here we go. Wow. Okay, 1418. Oh, okay. Redemption. Come on. It's moving so slow here. There it is. Redemption, 16th century. The act or instance of reclaiming or regaining possession by paying a specific price. In bankruptcy, it's a debtor's right to purchase property from a buyer who obtained the property at a forced sale initiated by a creditor. So, yeah, let's see what we say here. I would say to claim ownership legally in this instance. Perhaps. Like, yeah. Do they even use that term anymore? 1, little 2, little 3. Okay. The acquisition of a security by the issuer. The reacquisition. So it's the repossession. Redemption usually refers to the repurchase of a bond before maturity, but it may also refer to the repurchase of a stock in mutual fund shares, also termed, stock redemption. Property. The payment of a defaulted mortgage debt by a borrower who does not want to lose the property. So it's the payment of a defaulted mortgage debt, also termed dismortgage. see equity of redemption. And that's cases mortgages, right? Redeemable, redemptive, redemptional. All right. Let's see here. Statutory redemption. What was the one we were looking at here? Equity of redemption. But that's the equity of redemption. It's going to be under equity, isn't it? Let's see if it's over here. Okay. Well, here's a good word here for everyone. 1884, really. Red herring. An irrelevant legal or factual issue, usually intended to distract or mislead. Okay, let's get back here. So, as we were saying, permanent redemption, to purchase it back, so to pay the debt to be made at the time within 90 days thereafter upon terms that are equitable and just. So the court can order that. All right, that took a lot to get through. Now we're on to 1302, Section 2, 1302, Notice of Entry of Default Order. Upon entry of an order of default, the attorney for the moving party, the plaintiff in this case, shall immediately give notice thereof to each party who has appeared, against whom the order was entered, or such party's attorney of record. However, the failure of the attorney to give the notice does not impair the force, validity, or effect of the order. The notice shall contain the title, number, court, date of entry, name of the judge, and state that the order was one of default. So we look for that order of default judgment here. That's going to be it will be a default judgment ordered by the court. The notice may be given by postal card or in any manner provided by rules. In the case of an action for foreclosure of a mortgage or a deed in trust. In addition to the information required by subsection B of this section, the notice shall state that the defendant or defendants may redeem the property within the time and in the manner provided by law. So in the case of an action for foreclosure of a mortgage or a deed in trust, right? In addition to the information required by subsection B, right? The notice shall state the defendant or defendants may redeem the property within the time and in the manner provided by law, which is 90 days, I believe it said here. No notice of the entry of an order of dismissal for want of prosecution shall be necessary provided plaintiff has been notified in advance that the court is considering the entry of such an order, unless required by local rule. Entry of an order of dismissal for want of prosecution shall be necessary. So, That's okay. So yeah, some of this language here makes American jurisprudence seem like poetry. This stuff is hard to read. Interest on judgment. So acceptance provided, recovered, okay, draw interest. So they're dividing up the, we can, all right, notwithstanding prosecution or steps to reverse, vacate. Okay, so this is all about money here, interest. Jeez. As used in this section, consumer debt is property or the equivalent. Due or owing. Consumer debt judgment means a judgment recovered in any court against one or more natural persons.
Bro, you said this stuff. You said this stuff. Hello?
Yeah. Oh, hang on a second. Let me get you off of the. There you go. I hear you.
Yeah, you said this stuff makes Amger look like poetry.
Yeah.
So, how?
Because this is all. This is legal stuff. It's not law. This isn't speaking to intent. This is speaking to just strict procedure to keep people doing things a specific way so that it can be controlled. It's not really looking to meeting the needs of life as much as the law it does. This is a way of just kind of administering the law, I guess you could say.
No, that's slick, bro.
You know, it's see how they have to redefine things. A consumer debt judgment means a judgment recovered in any court. So this is where it gets specific. You know, Amger will reference these things. You know, look at your statutory definitions. In some statutes, in some states, it's this. In some states, it may be that. But it helps you understand when you're reading these things from a deeper understanding, so that when you are reading them, you can kind of see the deficiencies, or you can see the sharpness of how they've chosen certain words and the limits of definitions to keep them within the context of what they're trying to serve here. It's kind of a way of, to me, it's more of a reductionist approach to administering law. But again, this is a function of people that aren't trained or taught to be able to govern themselves according to the laws that have been pretty much developed with our social contract as part of civilization. And it's an interesting way to look at things. So I gotta get this chat back up here. Just tied it. Okay, there we go. But either way, this is stuff that you have to read because this is where the rubber meets the road when you're in court. So again, consumer debt, see, they have to define it. Consumer debt judgment does not include any compensation for bodily injury or death. See, this is all about real property here, right? So it has to separate that kind of stuff. Consumer debt judgments of $25,000 shall draw interest. So again, here, so when you make a claim saying I want to get interest based on this judgment at 5% per annum, that's because it says it according to the statute, and the court in that particular jurisdiction will say, okay, yeah, we're going to comply with our statute, of course. You try to say 6%, then the other side would say, objection. But if they don't object, you might be able to get whatever you want, unless the judge says, wait a second, that's outside of procedure. But typically, that's why every side has to scrutinize what's going on, because errors can be made. If they're signed in by the judge in error, it can still carry the force of law. All right, the judgment, or the legal force, I should say. The judgment debtor may, by tender of payment of judgment, costs and interest accrued, stop further accrual of interest, okay. Subsection applies to all consumer debt judgment entered in the effective date of this amendment, okay. All actions brought to recover damages for personal injury or wrongful death resulting, right. So all this language is here for, that type of thing. If you're trying to sue for bodily injury and things like that, wrongful death, willful strict liability of things, 6%. So yeah, okay. So this is just getting to be 90 days. So this is all your stuff here for these particular things, but this is getting outside of the topic here for tonight. We're not looking at the wrongful death. Orders for liens and other conveyances. Whenever, by any order, any party to an action is required to perform any act other than the payment of money, or to refrain from performing any act, the court may, in such order, provide that the same shall be a lien upon the real or personal estate, or both. I'm sorry here, until the error is corrected.
Hey, your microphone is going in and out. See that?
My microphone? Let me see if I can fix it here. Just a second here. Let me see my mic. See if there's something with the filters here. Let's see here. Check 1 2. Do the compressor here. Let's see if we can just do a little here or less. Check 1 2. Check 1 2. All right, how's that? Check 1 2. Check.
No, the mic is on now.
All
Perfect.
Right. Cool. Okay. Yes, an incorrect judgment will stand. It's going to have to get corrected under appeal if that happens. That's the only trick there. See, if nobody catches the error, it's going to stand. Someone has to catch it. Put it this way, if the plaintiff puts something in error in his favor, he's not going to point it out to anyone if it gets ruled in their favor. And I've seen this happen a lot in courts, believe it or not, that they'll always try to pull something on you until you catch them in it. And then it's like, you caught me. There's really no price to pay, it seems. I mean, you might piss off the judge, I guess, but who's to say? Okay, so as we were saying here, the court may such provide that the same shall be lien upon the real personal estate, or both, of such party until such order is fully complied with, and such lien shall have the same force and effect, and be subject to the same limitations and restrictions as judgments for the payment of money, including the time and manner when the same shall take effect, and the time and manner when the lien upon a revival thereof shall take effect. So, so that's what's called a judicial exception, I believe. And before I say anything further, I just want to remind everyone of this. I have absolutely no legal lawful knowledge. I'm not professing to give any kind of advice, recommendations, legal help of any way, shape, or form. This is strictly for entertainment, educational purposes, as we're just reviewing the Illinois compiled statutes. Don't try this at home. Okay, so the judge erred, and you're working to correct it. So you'd have to enter a motion of probably for a judicial determination for the exception, for the error, and they would have to answer that motion. And you'd ask for grounds for, I mean, there's formal ways of doing that, of drafting that motion for judicial determination. I've actually done that before myself, and it gets a response. Let's just say that way. It definitely gets response. I won't go any further detail. But yeah, that's something where you want to correct exceptions, and you need to you got to give them an opportunity to make that clear. That's all it takes. Typically, it's going to be a real hard bar for them to pass. Okay. Whenever an order is entered directing the execution of any deed or other writing, it shall be lawful for any judge of the court to execute, or for the court to direct the sheriff to execute such deed or other writing, in case the parties, under no disability, fail to execute such deed or other writing in a time to be named in the order, or on behalf of minors or persons under legal disability who have guardians. And the execution thereof shall be valid in law to pass, release, or extinguish the right, title, and interest of the party on whose behalf it is executed, as if executed by the party in proper person. And he or she were under no disability. And whenever any property is sold in open court, it shall be lawful for any judge to execute a deed, certificate of sale, or bill of sale, or for the court to direct the sheriff to execute a deed, certificate of sale, or bill of sale to the purchaser. Therete, and execution thereof. Okay, there's a word that I don't know.
Oh wow, you see, that's the amazing thing. They always use words here and there,
Here and
like
there.
that. Yeah.
Gosh, I can't even spell it. It's trying to remember how to spell it here. The REIT. Okay.
The REIT.
The REIT. The REIT. It is. Only one entry, that one. Oh, Lord. 1644. All right, give me a second here. Gotta get over the blacks.
If it's not one thing, it's another.
Yeah, it's so funny. What was it? The... Come on.
THEREAP.
The REIT. The REIT. There. So where did I pass it? Oh, jeez. The REAT. There it is. The REIT. Holy shit. 12th century. At that place or time. There. because of that, at that occurrence or event. Oh, 12th century.
Commencement. That's like saying commence.
No, at that occurrence or event, at a place or time.
Thereat.
There. It just
At
means
that
there.
place or
It
time.
means there. They're
There.
at. They're at.
Right. Thereat.
No,
Yep.
they're at.
It's Esquire language, bro. Instead of saying there, you have to say thereat.
There.
Your Honor, persuasion.
Holy shit.
Your Honor,
It's there at.
thereat.
It's there
They're at.
at.
They're
It's
at.
At.
Oh,
there.
there it is. That's right. And we're
There
reading it saying
at.
thereat.
It's there
It
at.
is. Yep. They're at. It's right. It's written there without no comma or period. It's there. They're at.
Damn Esquires.
And we were saying the read. You see, that's that's language, bro. That's language.
Damn. All right, we learned something tonight. To the purchaser thereat, and the execution
Thereat.
thereof. Oh shit. Okay, thereat, thereof. I bet there's a few other variations too.
Thereat and the execution
Shit.
of thereof shall.
Thereat, and the execution.
Every day is a
thereof.
learning. Every day is a learning process. You know.
Yeah, two great. So thereat and thereof. Nah, makes sense.
Right.
Shall be valid
Thereat
in
and
law to pass, release or extinguish all right, title, and interest of the
Amazing.
parties to the action with the same force and effect as though such sale had been held by the sheriff pursuant to the court's order, and such deed or other writing, if it relates to land, shall be promptly after its execution by a judge or the sheriff be recorded in the recorder's office of the county wherein the land is situated. So again, here we're looking at the conveyance, right? The transfer of the property, the voluntary transfer of property. Now, since it seemed voluntary, that's why they don't say conveyance here. Let's see what it says here. Motion to stay. Now, remember we saw it before. It was a motion. What was the other one? It was a motion to abate. Motion to abate or motion to stay. So let's look at this motion to stay. A party intending to move to set aside any judgment, bond, or other proceeding may apply to the court or to the judge in chamber for a certificate, which the judge may, in his or her discretion, grant that there is probable cause for staying further proceedings until the order of the court on the motion. Service of a copy of the certificate at the time of or after the service of the notice of the motion stays all further proceedings accordingly. In no case shall the judge grant the certificate if the error complained of may, by the direction of the judge to the clerk issuing the process, be corrected. But the judge shall order, and the clerk shall make the correction in the process, nor unless why does it say not unless? Nor unless the applicant has given notice of the motion to the opposite party, or his or her attorney of record, if they or either of them can be found in the county where the judgment was entered. Wow.
Nor unless, probably because it says or right after that.
Okay, nor unless or, but that's, oh jeez, man, that's really sloppy. I guess it's not sloppy, it's just too legalese sounding. They do this on purpose to make it difficult to read.
Nah, but I like the ILCSs, bro. The way this shit is written, it's the best.
Nah, I don't like any statutes. These are not
The
law.
proof of facts.
This is
The proof of fact.
This is, remember, these are statutes, so this is legal
Right.
crap. This isn't law. This isn't the fundamental substantive
Yeah,
stuff.
it's all fuckery, but
This is all statutory. This is not common law. Common law is the beautiful
they
law.
wrote it. They wrote it in
This is a quasi law. This is a
right.
pseudo civil, part administrative. Really, the way this is written. If you read it carefully, you can see it's
The real shit. The common law is the AMJUR. American
Yeah,
jurisprudence.
Deborah has a good nor unless, not unless. Yeah, but they use nor instead of not, and then they use or later on just to make it complicated. So is it a compound logical statement of nor and then or, like as if parentheses around it?
You know what, bro? We got to take them to trial.
Yeah. Well, it's going to be. I mean, you'll have to
We got
justify
to take the writer.
the
Let's take the
interpretation.
writer to trial.
That's why I like to understand this
Yep.
stuff deeply, because if I can at least articulate my point of view to you guys, then it would make sense that if I'm wrong, I'd have someone on the other side has to have an even more clear understanding of this, and I doubt many of the Esquires, unless they just deal with this on a daily basis, read this deeply. Sometimes they mostly go by cookie cutter cookbook approach. And these judges too, unfortunately. I mean, I don't know how they are in Illinois, the judges, but in Florida, we've had a lot of problems. Okay, so where were we here? So notice the motions say all further proceedings accordingly. So in no case shall the judge grant a certificate if the error complained of may, by the direction of the judge to the clerk, issue it be corrected. So if there's some kind of error that can be corrected, then the judge won't have to stay the case. But the judge shall order, and the clerk shall make the correction in the process. Corrected, but the judge shall. Oh, gosh. Okay, I think we kind of get the gist of this here. If it can be corrected by the clerk and the judge ordering it corrected, then it would correct the reason for the stay, so there would be no stay. They would not hold the proceedings, and the order would continue through. I mean, it would move forward. All right, supersedious bonds. In civil litigation, under any legal theory involving a signatory, a successor to a signatory, or a parent or an affiliate of a signatory to the master settlement agreement described in section, have you seen this one? 6Z-43. So scribble that down with your Esquire pen, guys. We're going to have to come back to that. Of the State Finance Act. It's in a different book. Execution of the judgment shall be stayed during the entire course of appellate review. Okay, so this is a appellate case. Notwithstanding subsection A of this section, so we're not doing appellate. I see what they're talking about here. It's an appellate case. When you're reading these statutes, they just don't want to use normal language. Relief from final orders and judgments after 30 days from the entry thereof may be had upon petition as provided in this section. Writs of error, coram nobis and coram vobis, bills of review, and bills in the nature of bills of review are abolished. All relief heretofore obtainable, and the grounds for such relief heretofore available, whether by any of the foregoing remedies or otherwise, shall be available in every case by proceedings hereunder, regardless of the nature of the order of judgment from which relief is sought, or of the proceedings in which it was entered, except as provided in the Illinois Parentage Act of 2015. There shall be no distinction between actions and other proceedings, statutory or otherwise, as to the availability of relief, grounds for relief, or the relief obtainable. The petition must be filed in the same proceeding in the order of judgment was entered, but is not a continuation thereof. The petition must be supported by an affidavit or other appropriate showing as to matters not of record. So whatever's not in the case, you'd have to have an affidavit or appropriate showing to the matters that were not in the record of the case. So a petition to reopen a foreclosure proceeding must include, as parties to the petition, but is not limited to, all parties in the original action, in addition to the current record title holders of the property, current occupants, and any individual or entity that had a recorded interest in the property before the filing of the petition. All parties to the petition shall be notified as provided by rule. Okay, so you get this here. This is important stuff here for Section B. A movement may present a meritorious claim under this section if the allegations in the petition establish each of the following by a preponderance of the evidence. What does that mean? Preponderance is when you're weighing the evidence. One has more than the other, so it's not absolute. It's not like, a beyond reasonable doubt kind of thing. This is a preponderance of evidence. It's a big deal in these cases to note this language. The movement was convicted of a forcible felony. The movement's partition, the offense was related to him or her previously have been victim of defect. Oh, gosh. So none of this stuff here. It was aware of mitigating nature of the evidence of the domestic violence. Jeez. New evidence of domestic violence. Jeez. Nothing is... It's all about domestic violence? Yeah. Relief under this section. Okay, so domestic violence means abuse is defined. Forcible felony, intimate partner. Movement may present a meritorious claim under this section if the allegations of the petition establish each of the following by preponderance of evidence. Oh, so this is criminal stuff here. Jeez. Okay, I think we've gotten... Boy, they really have this stuff hodgepodged in here, don't they? Yeah, greater than 51%. I mean, if you want to say 50, you might not have all the evidence there on the table. All right, so here we go. Distribution, watercraft. Okay, so distributions, seal, bill of sale, copy. All right, so this is watercraft now. And how we got into watercraft? Let's see what else we got here. Costs. I think we might have finished up the whole section there. We're looking at, but there will be more. All right, so now we get into the fees and the court costs and all that stuff. I get that. All right, let's see here. Unit agent. So it'd be nice to have a table of contents in here, but they don't. Yeah, see, this is the beginning here. Check the headings. Yeah, it's not very... Yeah, it's not too well organized, I'll say that much. But I'm sure there is probably another document that has an index to all this. Correct, Audit Dem? Do you know where you'd find the index to all this? All right. Is Audit Dem's out. We lost him. All right, so he'll be back. Wait for him to get back in the house here. Stop that camera there. All right. Oh. Greater than 51%. That's the one I wanted up there. Yeah. Okay, so there we go. That's the we went through the whole part there about the property. Provide links to this. Yeah, this is the ILCS Illinois compiled statute, civil procedure. So 735 ILCS Code of Civil Procedure, and that's what this is. That's what this is called. And we were looking through the sections that had to do with property and transfer, through the court through orders of foreclosure and other types of possession. There's also the limits of the statutes of limitations for things like adverse possession. But what we were looking at here was the legal apparatus that's in full force right now that's moving property in unprecedented ways. And we should be aware of this that's happening every single day in every courtroom, in every county, in every state. And some of the things that are going on may or may not be lawful in a strict sense. However, they are legal. So it behooves the people to learn about these procedures and where they stray from the intent of the law which is to adapt to the needs of life, and not for life to adapt to the needs of these codes and statutes. So our common law is really what we want to protect in this country, because as you can see, these procedures and statutes and such do nothing but corrupt the law. The law should be simple and straightforward and substantial, and not statutory and it's just overly scrutinizing and micromanaged in ways, which I kind of understand when it comes to commerce. But when you're involving men and women, this stuff is it's an inappropriate level of precision, in my opinion. That being said, yeah, I'm going to see if Audit Them's back yet. I still don't see Audit Them here. Audit Them, are you coming back in on the video? If you want to log back in, I can get you back in. So, Deborah, you were looking for links to the Illinois statute? But whatever state you're in, you should be able to find your rules or code of civil procedure, which is what this is. And it's basically the rules that your courts will follow. And it's going to have in here examples. Let's see here. And we get some, oh, geez, there's a good one here. Postponing the sales. Give me a second here. There's another one here. Yeah, so there's a lot of nice things in here for, yeah, see this here? This is the new stuff they put in here. Until January 1st, 2023, with respect to residential real estate, at the time of the filing of a foreclosure complaint, and in addition to the fee set forth in subsection A of this section, the plaintiff shall pay the clerk of the court in which the foreclosure complaint is filed a fee for the Foreclosure Prevention Program Graduated Fund. What is that? And the other one we're looking at, the Abandoned Residential Property Municipality Relief Fund, as follows. So they have to pay to these. So when the plaintiffs, the banks, they have to pitch into these two funds. $500 of the funds. The plaintiff, together with its affiliates, has filed a sufficient number of foreclosure complaints so as to be included in the first tier foreclosure filing category. So this is some interesting stuff we need to look at here. The Foreclosure Prevention Program Graduated Fund. So there's, in Illinois, you have a foreclosure prevention program. An abandoned real estate property municipality relief fund. A link to the jurisprudence. Nope. You could go to Westlaw and get a subscription to it. Or you could go to your local library, law library, and read them there. But yeah, for the most part, they're not readily available online unless you have a subscription to something like Westlaw, where you can get to the to these things. So again, so the plaintiff, together with affiliates, has filed a sufficient number of so that's an interesting thing to look up. I'd be interested to see what they have that for. This is the problem when these laws get to be against the needs of life, that they have to do things like they have to create these types of funds. You know, it doesn't make sense that this late in the game that they have to start thinking about things like this. That's something else has gone wrong for us to get to this point. What do municipalities have to do with abandoned residential property? That's for the people. Anyhow, let's see here. Well, you can always get it free here. So put in your request for what you'd like to review, and we could review it here. I have tons of this stuff, so I'm always looking to find what's interesting to people to do, because I could go on this all day and talk to myself about it, and I'd read this stuff for my own enjoyment. Well, not this, but American jurisprudence. So if there's any topics of interest, I could even go through, the catalog here of what I have available. and we can pick some good topics to go over. And we have been going over some great ones, and I think we're going to be going over a few more in some more detail, because I know the titles, the trusts and the deeds, things like that are really, really interesting topics. And when you're talking about things like money and private property, land, those are relevant topics for everybody that's alive. So I think it's one of those types of things that we can all benefit from learning more about. And I also have some other pretty interesting topics to go over too that might be of interest to people. It might be a little bit more interactive than just reading through documents, but some of the new developments in artificial intelligence. There have been some remarkable, I shouldn't say breakthroughs right now, but there's been some tremendous, unprecedented access for the people to use some of these tools. And they're nowhere near the level that industry and government has with them. However, just the fact of seeing what's available to the public is mind-blowing. Then to think what's behind the paywalls of this stuff for industry it makes like the Matrix red pill kind of thing look like Tic Tacs, the kind of things that are really around the corner. Believe it or not, what we're really looking at this point is every job that you know of today to be changed or to go away, which means that we'll have even less labor to be used as a way of distributing wealth. And then the whole labor theory of value is going to become even more and more deprecated, to the point where what are we going to choose to do as a society for distributing wealth? So there's some pretty interesting developments in the scientific world that are making their way into the whole of society now. And it would be to our detriment to ignore and to not try to learn as much as we can about these new tools that are going to change the entire fabric of society in the next, maybe not even 5 years. So you heard it here first, that there's a sea change about to happen. It's probably only within the last month, but you're going to see the whole landscape of labor change very rapidly. It's been a long time coming, but it's finally happening now, because once they let the genie out of the bottle like they have now, it's going to be just a snowball event, and it's going to be a roller coaster. So what we can do here is be prepared for it. We're going to learn all we can about these tools, how to use them. For those that want to go along for that journey, I'm going to be here learning along with you, just like we have been learning our common law in the form of American jurisprudence, which is, I believe, the true strength of our nation. And by ensuring that we have our due process afforded to us, that these great accomplishments of law will be preserved for ourselves and for posterity. So with that, I would like to thank you all for coming along. And I encourage you all to subscribe and make sure you hit that bell notification. Deborah Rogers, no. There will be no work from home. Essentially, here's the message I'll leave everyone with. If you consider yourself a non-essential worker, you are. So no one should be able to work from home, because if you can work from home, that's devaluing you as a person. So in essence, if you could work from home, it's only a short leap for a robot or artificial intelligence to do your job. Don't think for a second that most of what you see online is artificial intelligence. Every news heading you read, every LinkedIn profile of a top executive you read, movie scripts, yes, advertisements. It never ends. The level that used to be the domain of human creativity is now in the realm of science and a reductionist attitude that is devoid of the meaning of life and has no spirit or soul. So the facility it's able to produce deceit is unprecedented. And the ignorance that has been inculcated into our society has made it totally feasible and likely, and it actually has made it effortless for those in power to further enslave all of humanity. And if we don't do something in this generation, there's probably going to be no way out for the next. It could be a very long time until we see the kind of freedoms that we held dear to us here in this country. Oh, there'll be a need for humans, but not as you think. There'll be a fork in the road. And at that fork, we're going to decide what the fate of the people will be. You know, you need probably at the very most 10% of the population to run all of civilization. So what do you do with the other 90%? Yeah, there's going to be, well, I'd like to explore these topics because they will be in our face very shortly. And I'd like to share some of this insight with you guys out there that are willing to participate in this, because it will be affecting us all. And the more we know, the better prepared we are, the more we can hopefully benefit from it rather than succumb to it. Okay, on that note, guys, I appreciate you coming along with me on this journey. I hope to see you all on the next one. On that note, I bid you all farewell, good night, and peace out.